argument, and 19, or over a third, were 6-3 decisions. No longer is there a swing justice. Gone are the days when a Republican-appointed justice might turn out to be liberal, or even moderate, on key issues. Nor is this likely to be for just the short term. In 2022, the oldest justice, Clarence Thomas, is 74. Justice Alito is 72. Chief Justice Roberts is 67. And Justices Gorsuch, Kavanaugh, and Barrett are all in their 50s. I have long thought that the best predictor of a long life is being confirmed for a seat on the Supreme Court. Justice Stevens did not retire until he was 90, and Justice Ginsburg remained on the bench until her death at age 87. It is easy to imagine 5 or even all 6 of these justices being on the bench for another decade or 2. And there is the prospect that the next time there is a Republican president and a Republican Senate, the older of these justices might retire to keep the seat in younger, conservative hands. In the case against the Supreme Court, I argued that the Supreme Court often has failed to enforce the Constitution and fulfill its mission, frequently, at the most important times in American history. When I consider the court in 2022, I am struck by how many of the court's recent decisions have not just failed to interpret the Constitution and to uphold its values, but have moved constitutional law far to the right. It is a conservative court with a very conservative agenda and intent on implementing it quickly. I now observe the court actively engaged in eliminating basic rights, centering on the privacy-based right to an abortion, obliterating the wall that separates church and state, and aggressively protecting gun rights. The triad of abortion, religion, and weaponry are not by coincidence 3 of the crucial planks in the most conservative wings of the Republican agenda. Removing constitutional rights. In theory, the Supreme Court's duty is to protect the rights of its citizens, so it is extraordinary to witness the Supreme Court taking away constitutional rights. But that is exactly what occurred in Dobbs v. Jackson Women's Health Organization, when the Supreme Court explicitly overruled Roe v. Wade and held that the issue of abortion is left to the political process. Justice Alito wrote the opinion for the court, joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. Chief Justice John Roberts concurred in the judgment. He would have upheld the Mississippi law prohibiting abortions after the 15th week of pregnancy, but not have reached the question of whether to overrule Roe. Justices Breyer, Sotomayor, and Kagan wrote a vehement joint dissent. Respecting precedent, the rulings of the previous justices, is a fundamental aspect of American jurisprudence. It provides essential stability and predictability in the law and is supposed to lessen dramatic changes just because there are new justices. Indeed, at their confirmation hearings, each justice has pledged fidelity to stare decisis. In Dobbs, Justice Alito, writing for the majority, said that a constitutional right exists only if it is in the text of the Constitution or was part of its original meaning, or if it has been safeguarded by long, unbroken tradition. The court said that abortion meets none of these requirements. It obviously is not mentioned in the text and was not part of the original understanding of any constitutional provision. The court said that Roe should be overruled because it was egregiously wrong. The court declared, "We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives." Precedent established firmly by a previous court now was utterly disregarded by a court with a different opinion and agenda. Justices Breyer, Sotomayor, and Kagan wrote an unusual joint dissenting opinion, and it was, as expected, passionate and angry. They stressed that some states already had banned abortion from the moment of conception, and that these laws would now go into effect. They explained that the effect will be that women in states where abortion is illegal will travel to places where abortion is allowed, if they have the resources to do so, but that poor women and teenagers again will face the cruel choice between an unwanted child and an unsafe back-alley abortion. Because of the correlation between race and poverty in the United States,